I think it's unprecedented that there have been so many lawyers, so many senior lawyers, well-known lawyers who've come on the web now on various forums and shared their knowledge, judgments, information, strategies. And I think that's a beautiful takeaway from this COVID 19 being locked up at home. That information only, knowledge only increases once it's shared. Just to give a big brief background in the meanwhile, I've been a lawyer for around 20 years and more. I've started from Tisazari, that's my mother bar, and it took me a number of years to actually move from Tisazari and come to High Court and to Supreme Court and appellate courts. And it's been a fantastic journey being a first generation lawyer. I used to tell my friends I don't even know how much to charge. So those who have parents or relatives in the profession, there is an added advantage that the basics are clear to you. Well, the basics are very difficult for a first generation lawyer. And when I started as a lawyer, I actually had thought that given a chance, I would like to share whatever little knowledge I have. And God's been extremely kind that there have been a number of forums, but lawyers' wit is extremely close to me. I'm extremely fond of Tadween, a very, very bright lawyer, and Kawalji, again, a very resourceful and a very bright counsel. I've had the good fortune of knowing both of them now for a number of years. And when we were discussing as to what topic should be taken, and a lot of topics were put across, criminal law, something where we have a huge presence, art of bail, white collar crimes, PMLA. My advice was that we should bring in something which is new, which is not being explored, and the whole idea being that the younger members of the bar can probably have a huge takeaway from it, have a huge learning experience. And whenever a new bar or a new forum or a new tribunal or a new law comes up, it usually benefits the younger member of the bar because that's somewhere where there are no established lawyers, there's no established game, so to say. Judgments are being formulated, law is being understood. The points of argument are fresh, and there's a lot of opportunity for younger lawyers not only to earn but also to create a name for themselves. And I've always believed that money is a byproduct of success, never the other way around. So if you're able to succeed in a particular forum, in a particular place, it's much better because money, reputation, name, fame, all of it would come from that hard work, from the reputation, the good reputation that you've built. Any which ways, I think we'll start. We've given some time and people can join in. So as I was saying, when we decided on this topic, telemedicine is a new kid on the block. Telemedicine laws were not really formulated. There was a lot of confusion about whether telemedicine is in fact legal or not, whether the system is valid or not. And there have been extensive arguments over the years. And the interesting part is that telemedicine, though is an established system of medical healthcare in foreign countries, USA, UK, even in those countries, the law is constantly changing because what's been realized is that telemedicine law, which has, of course, direct connect with consumer law and law of torts in the civil, also has deep roots in IT Act, also has deep roots in criminal law. So it's probably a law which is going to benefit lawyers in all facets of law, be it be criminal law, civil law, consumer law, uh, information and technology law, data science. So the field is really, really big. The advantage to younger members and to other lawyers is also very, very big. And another huge advantage is the whole concept of telemedicine enlarges the reach of smaller doctors. So you have brick and mortar stores, big hospitals, Apollos of the world, which have spent crores, hundreds and hundreds of crores, and they bring in patients. Now there could be a doctor, a small-time doctor with a small clinic, probably in Trans Jamna, probably in Shahadra, probably in Ghaziabad, and that doctor has a very limited reach. He might be a very good doctor, but the reach is very, very little. The reach is in the locality, and if he's very good, probably from word of mouth, from someone in the same state might come to see him. But what happens with telemedicine is that that particular doctor, if he's smart, if he's savvy, if he's if he has some basic understanding of technology, has a reach of serving patients all across India. So as I said, somebody sitting in Ghaziabad or Noida or Trans Jamna in a small time clinic with the help of a fast internet connection, WhatsApp, telephone calls, can probably be servicing, catering, serving, helping a patient in Kanyakumari, in Northeast, in the interiors of villages. And how does that help you as lawyers is this, that as, again, I'll come back to younger members of the law because that's something which is extremely close to me. As I said, as a first generation lawyer, I've always tried to find avenues of growth. It's been 20 years, but I'm still young at heart. So the whole concept is this, that probably you as a lawyer who's smart and savvy can cater to those doctors, because right now those doctors do not really know what telemedicine laws is all about. It was brought in on 25th of March 2020. The guidelines are fairly new. There have been a lot of issues pertaining to its legality and validity. But what has happened is this, that on 25th of March 2020, the central government expedited bringing in guidelines pertaining to telemedicine. The reason, of course, was COVID-19, that the doctors could not serve the patients, they could not go out, there was a lockdown, there is a lockdown in fact. But the whole idea behind telemedicine was to expedite and ensure that doctors can treat patients safely and securely from their own clinics or from their own homes without having to go out. Of course, the guidelines, as lawyers know, that the preamble of any act is its soul. And so I've always told everyone in my office and briefing councils, always read the preamble whenever a new law or new act comes into place. So when you read the preamble, when you read the guidelines, the purpose of the guideline is very beautiful. One, of course, it is during such a time to be able to provide medical services. Second is that it may be provided expeditiously in cases where in-person consultation is not required, which means that the doctor does not really have to meet the patient. Then, with keeping in view the financial constraints, so the medical services being cheaper, being affordable, especially in the rural areas, etc. So these are very, very important guidelines or preambles to the guidelines, or purpose why they had been brought in. Now, another important aspect is that when you are able to explain to a small doctor or a single practice doctor or a small clinic or a small hospital of the advantages of telemedicine laws, they would require your services. They would require your services because you will be able to guide them about contract laws, about the issues of jurisdiction, about the issues of information and technology, data, privacy laws. There would be an issue as to jurisdiction. So as far as consumer laws is concerned, and you know that 2019 the consumer law has come afresh, which has of course still yet to be enforced, but still. And then also on the criminal ramifications, because that's also an aspect that is going to grow. Understand this again. A small doctor or a doctor that does not have a big brick and mortar store but is a good doctor is now able to cater to 100 plus patients that he couldn't before because they could not come to him. So he's reached out to them. His practice has increased, which means that the chances of litigation has also increased. And that is where you come in. You guide him as to what the guidelines as telemedicine are. You guide him as to what the consumer laws, the criminal laws, etc. are. And therefore, you're able to create a niche practice for yourself. Now, the issue is that telemedicine has been practiced in India since the year 2000. Dr. Abdul Kalam Azad had, in the beginning, initiated telemedicine that was more for the army and for rural areas. But there have been a lot of confusion regarding the validity and legality of telemedicine laws. There has been cases, especially in Karnataka, where the state medical councils had warned the doctors that they cannot practice medicine by telemedicine means, by WhatsApp, etc. And that strict action will be taken against them if they are caught doing so. In 2018, and just to stop here for a moment, because we are all lawyers, what I will do is that I will give you landmark judgments. I will give you judgments on each and every point with the citation, so that you can, as to say, land running in the field. You can just note down these judgments and citations, and these judgments would be applicable in whatever situation a client is in when you're preparing his matter or giving him advice. And we will also discuss some international precedents, because telemedicine is already an established practice in the US of A. So to come back, in 2018, the Mumbai High Court, in a judgment, the name is Deepa Sanjeev Pavaskar judgment. What had happened in that judgment was that two gynecologists were denied bail by the Honorable High Court on the grounds that prima facie they were criminally negligent towards their patient who had unfortunately died. The deceased patient had presented herself to the clinic with fever and severe vomiting. The doctors were not present in the clinic, but the nurse and somebody else who was present in the nursing home had, without examination, admitted them to the nursing home. The doctors had listened to the ailment on the phone and told the nurses what medication and etc. is to be given. The patient unfortunately expired. The Honorable High Court of Mumbai said that this was a case of criminal negligence and anticipatory bail was denied. There was a huge furore in the medical community, because this itself stated that the medical practice of telemedicine was illegal, and crores of rupees by companies like Apollo, etc. had already been put in. A lot of international companies have already come to India with the softwares, etc., to help in the telemedicine practice, because it's after all a huge avenue of growth and income for hospitals, etc. Now, since there was a lot of uncertainty, these guidelines that came in have put that uncertainty to rest. As I've already told you, that the preamble is to make healthcare more affordable. It is to be able to give healthcare in cases where in-person consultation is not required. And now, importantly for us lawyers, creating better system of record management, thereby increasing legal protection for both the parties. Now, a caveat here, that the guidelines really do not deal with how the record management has to be done. Who is going to safeguard that record management? What happens if that record gets leaked and some person, a patient, there's a breach of confidentiality or privacy, which is something that we will deal with. We will touch the IT Act just to understand this in its current light. Now, the reach of NCDRC in cases of negligence has increased, and I will start with a judgment which is landmark, because this is a case where probably one of the highest compensations had been awarded. This went all the way to the Honorable Supreme Court. This is called the Kunal Saha matter. It is a very, very well-known matter, or it's also called the Anuradha Saha case. This case was filed in 1998 against AMRI Hospital and its staff, doctors. The wife in this case was suffering from a drug allergy, The doctors were negligent in giving her the dosage and the kind of medicine. The patient's husband kept asking and questioning the doctors, who said that their prescription was like magic. Now, unfortunately, the wife expired in the final verdict given by the Honorable Supreme Court on 24th October 2013. A compensation of around 2.08 crore was awarded to the husband. Now, this judgment is extremely important because here, for the first time, the actual value of life of a person was quantified by the Honorable Supreme Court, and not just in peanuts, because they say that in India, the cheapest thing that you can purchase is life. The cheapest thing that you have in India is life. So, an exemplary award of 6.08 crore had been given by the Honorable Supreme Court in this judgment. I would strongly suggest that you read this judgment, more because you will understand that the nature of arguments that took place by the hospital, by the doctors, the issue of vicarious liability of the doctors also was dealt with in this judgment. Now, the legal perspective for us lawyers. What does this guideline, what do these guidelines do not deal with, which is very important. But first of all, the guidelines themselves are very clear. We will touch them very quickly only to help you, and you can take notes, only to help you talk to doctors, only to help you to understand the guidelines should you be reading them, and to understand, because the guidelines also are quite repetitive, also to understand which section of the guideline has to be linked to the other section for ease of understanding of the guidelines. We will also understand the data laws and IT Act. As I said, that these guidelines are completely silent on this, and this requires a deeper understanding by all of us. We will understand key concepts like negligence, like malpractice, onus of liability, liability under consumer law, civil law, torts, criminal law, very importantly. We will also deal with law of jurisdiction, because this is something that is going to be huge. The whole concept of jurisdiction will now change. Jurisdiction would now be on multiple point system, and you will have to understand whether you are to find out the jurisdiction in terms of civil law, which is quite basic, in terms of consumer law as it is, or consumer law 2019, or in the ambit of the IT Act and the judgments passed by the Honorable Supreme Court, as well as the judgments that may be referred of US of A. Now, before that, a caveat. To start, we all should understand that there is an exception to the law of tort for medical negligence. It says that if a doctor does not charge fees for his act, then he cannot be sued for medical negligence under tort or consumer court. Because this is as per the definition of service under section 2L of the Consumer Protection Act. But an interesting part of the guidelines is this, that the guidelines do not differentiate between paid and unpaid medical service or medical consultation. It says that if you are doing teleconsultation, you will follow the guidelines, otherwise you will be liable for penal consequences or actions under the Act itself. So therefore, irrespective of whether it is free service or paid service, a doctor will still be liable if he fails to follow the guidelines. So this is again an exception carved that you should be aware of. There is a landmark judgment of the Honorable Supreme Court. This is the Indian Medical Association versus VP Shanta. This is, the citation is 1995, volume 6, SCC, section 651. This judgment is extremely important, especially now, because while bringing medical profession into the ambit of consumer laws, the Honorable Supreme Court also carved few exceptions. It said whether the service of medical practice will be excluded under consumer law and tort or under section 2LO of the Act would be on two exceptions. One exception is rendering of personal service, important, rendering of personal service, and rendering of service free of charge. As far as first aspect, rendering of personal service is concerned, it said that a contract of personal service has been specifically excluded from the definition of service under the Consumer Act. It has been contended that the relationship between doctor and patient is in the nature of personal service. The court has held that the contract of service implies relationship of master and servant, or most specifically involves an obligation to obey orders in the work to be performed and to its mode and manner of performance. And now the important part. The distinction was drawn between contract of service and contract for service. So contract of personal service and contract for personal service. Rendering of personal service exempts you, but when there is a contract for personal service, it does not save you, exempt you. And the second, of course, is rendering of service free of charge. As I've already said, that the definition is clear. There would be no liability. However, this also, by a number of judgments, has been expanded. In certain cases, the liability will be there of government hospitals, etc., that are not rendering paid services. One of the judgments that you should probably know, which talks to the contrary, although this is the Assam High Court judgment, this is not a Supreme Court judgment, but this judgment also holds good because it actually carves an exception to this rule of exception. And this is Shishir Ranjan Saha judgment. This is a judgment of the Honorable Assam High Court. It is important because in this case, the patient had sued the government hospital for not providing services. The hospital did not have doctors present at that time. And he said that in addition to his claim for compensation, the patient had sought direction commanding the respondents, the government hospitals, to upgrade the standard of medical service for all the hospitals in the state, and in particular ensuring the service of specialized doctors in the time of need of the patients. Compensation in this case was awarded, and certain directions were given to the government regarding presence of doctors. Now, there have been similar judgments by various state commissions of various states, and these judgments have been after the judgment that I've already said, the Shanta judgment. And therefore, as I said, the NCDRC and state commissions have carved an exception to this exception as well. And this is very relevant to you as lawyers, because telemedicine is a set of guidelines which have to be followed by the doctors, and failure to follow them opens them to liability. It does not say whether the service, the telemedicine service or the medical service, is free or paid. And therefore, this is a huge advantage to you as lawyers to guide doctors in the correct format and the correct guidelines to be followed. Now, coming back to my friends on the criminal side, there are certain sections which are important when we talk about medical malpractice, medical negligence, etc. And I will quickly go through them. You're already aware of them, but there are 3 takeaways which are also important when you're creating civil cases or case for damage or under consumer law. One, of course, quickly 304A, you're already aware of that, but the rest is also important. Section 52 is important, which says nothing is said to be done or believed in good faith, which is done or believed without due care and attention. The takeaway here is good faith, due care and intention. 80, accident in doing lawful act. Section 81, act likely to cause harm but done without criminal intent and to prevent other harm. Without criminal intent is your takeaway from here. Section 87, act not intended and not known to be likely to cause death or grievous hurt, done by consent. Now, consent is something that the guidelines deal again and again with, and therefore this is very, very important. We shall deal with consent and the definition of consent in a while. Section 88, act not intended to cause death, done by consent in good faith for person's benefit. Section 90, consent not to be given under fear or misconception. Definition of consent is extremely important, guys. More because in American courts, in UK courts, and in German courts, there have been number of cases against doctors on whether consent was valid, whether consent was in good faith, whether consent was under duress or not. And that is something which is going to be decided by Indian courts again, more so now that the telemedicine laws are in place. Now, Section 92, act done in good faith for benefit of person without consent. Section 304, of course, causing death by rash and negligent act. Negligent is the takeaway from here. Section 337, causing hurt by act endangering life or personal safety of others. And 338, causing grievous hurt by act endangering life or personal safety of others. So there's a landmark judgment on the criminal side for my friends, and this is Qurban Hussain versus State of Maharashtra. This deals with Section 304A. The citation is 1965, Volume 2, SCR, page 622. In this case, the Honorable Supreme Court dealt with cases pertaining to medical negligence, etc., under Section 304A IPC, and they relied on a statement of Sir Lawrence Jenkins in a judgment, Emperor versus Omkar Ram Pratap. And the statement was this: to impose criminal liability under Section 304A IPC, it is necessary that death should have been the direct result of a rash and negligent act of the accused, and that act must be the proximate and efficient cause without intervention of another's negligence. It must be causa causa. It is not enough that it may have been a causa sine qua non. This judgment has been reiterated number of times, is a wonderful judgment, and it defines when you can when you can file a case under criminal negligence and not just a negligence under tort or civil negligence. Now, question is, what is telemedicine? And this is only for an academic purpose, so that you understand in what cases and what you can explain to the doctors. The World Health Organization has defined telemedicine as the delivery of healthcare service where distance is a critical factor by all healthcare professionals using information and communication technologies for the exchange of valid information for diagnosis, treatment, and prevention of disease and injuries, research and evaluation, and for continuing education of healthcare providers, all in the interest of advancing the health of individuals and their communities. The telemedicine guidelines adopt this verbatim. There is absolutely no change, and therefore this stands good in India as well. Now, the question is, who can practice telemedicine? Telemedicine can be practiced by any doctor or a registered medical practitioner who is enrolled with the state or with the Indian Medical Register under the IMC Act of 1956. Right now, any doctor or any RMP so registered can practice telemedicine. However, in near future, there would be a web-based online course which would be brought in, and any doctor or RMP wishing to practice telemedicine will have to undergo that course, but that is right now not there. It would be there somewhere in future. Ayush doctors, which is allopathy, homeopathy doctors, etc., are also permitted to practice telemedicine, and though they have also been brought in the ambit. However, these doctors are certified by the Indian Medical Council Act of 1970. Now, what do these guidelines specifically exclude, which is important? These guidelines explicitly exclude the following: specifications for hardware or software, infrastructure building maintenance, data management systems involved, use of digital technology to conduct surgical or invasive procedures remotely, which is explicitly banned, not allowed, other aspects of telehealth such as research and evaluation and continuing education of healthcare workers, and it does not provide for jurisdiction outside of India. Very important 3 takeaways. You see, a lot of medical tests for medicines, etc., take place in India. These guidelines do not talk about the parameters of such tests. And that is something which is also going to open a huge Pandora's box for us lawyers in explaining these laws to these hospitals and to companies that are into research and evaluation. And secondly, it is also going to create open a Pandora's box, because what is going to happen is that a doctor sitting in India can provide medical services, consultation to any patient in India. A question may arise that a patient who was in India, thereafter, for example, a patient who is in Kerala, goes abroad, goes to Saudi, and contacts his doctor sitting in Kerala for a medical condition. Can the doctor prescribe him medication or give him telemedicine consultation? The answer is no, but it is actually going to raise a lot of questions, because there would be a lot of questions, a lot of confusions regarding such situations where a patient who flies out for some time contacts his doctor in India, because till now these advices were, so to say, under the radar. There were no guidelines and there was no legality or illegality pertaining to that. Now they would be contrary to the guidelines. Now, the thing that we have to deal with is medical malpractice litigation. It has two basic requirements. One, there has to be a doctor-patient relationship, which means that consent should be there for the doctor to accept the patient and for the patient to accept him as a doctor. And the doctor must have breached his or her professional duty of care. Now, the Honorable Supreme Court in Lakshman Balkrishna Joshi matter, which is again a landmark matter, citation AIR 1969, Supreme Court 128, laid down that a doctor, when consulted by patient, owes him certain duties, which is a duty of care in deciding whether to undertake the case, a duty of care in deciding what treatment to give, a duty of care in administration of that treatment, and a breach of any of these duties gives a cause of action for negligence to the patient. The breach of duty may be occasioned either by not doing something which a reasonable man under given such set of circumstances would do, or by doing some act which a reasonably prudent man would not do. Now, this judgment has been relied in a number of other cases. This is a landmark judgment. This is a judgment that defines these three duty of care, and these are very important, especially in the issue of these guidelines, because here the doctor has the right to actually administer, to take the case. He has the right to say that I cannot take your case. To give the treatment, he can decide the nature of the treatment. He may say, no, I don't think you need to take this medicine. You first go and get these tests done. Or he may say that you come to see me in person. This right has been given in the guidelines. And care in the administration of the treatment to decide on the nature of medication that has to be given under the ambit of the guidelines that are there. The onus is very heavy, of course, we are aware of that, on a person who is alleging that a doctor has breached his duty. Another aspect of medical negligence is reasonable degree of care and skill. The Supreme Court, the Honorable Supreme Court, in another landmark judgment, which is Poonam Verma versus Ashwin Patel. This was a landmark judgment. The citation is 1996, Volume 4, SCC 332, has laid down test of breach of legal duty in rendering legal service. The Honorable Supreme Court defined medical negligence in various ramifications. It said that it can be an active negligence, it can be collateral negligence, comparative negligence, concurrent negligence, continuate negligence, criminal negligence, gross negligence, hazardous negligence, active and passive negligence, willful or reckless negligence, or negligence per se. This is again a landmark judgment where the Honorable Supreme Court directed the homeopathy doctor who was illegally prescribing allopathic medicine to pay compensation to the victim's widow, to the deceased widow. The third aspect is minimum technical standards, which have not been defined in India, but it basically says when a doctor is using any of these technologies, he has to have minimum technical standards in operating those technologies. For example, somebody doesn't understand WhatsApp, or somebody doesn't understand FaceTime, or any proprietary software is still trying to use it. The court says that you need to have minimum technical standard to give these services on the mode that you've chosen. In Supreme, for example, in USA, for example, there is an onus on the doctors to have a much higher standard of technical knowledge when they are giving telemedicines. Also internationally and more specifically in US of A, telemedicine practice is said to be a high risk business and entails a higher medical liability premium. It is not so in India, but it is bound to happen. The test of negligence or deficiency of service have been enumerated by the Supreme Court in various judgments like this. A legal duty of care, either express or implied, to treat patient must exist. A breach of such duty should have been there, and presence of damages should have been there. A landmark judgment for your record would be Jacob Matthew versus State of Punjab, which is 2005, Volume 6, SCC 1, where the Honorable Supreme Court differentiated between civil negligence and criminal negligence and said that negligence is a breach of duty caused by omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. The essential component of negligence are duty, breach, and resulting damage. It further held that a simple lack of care, an error of judgment, or an accident is not proof of negligence on part of the medical professional. And when it comes to failure of taking precaution, what has to be seen is whether those precautions were taken which the ordinary experience of men has found to be sufficient. You can read this judgment. This is a wonderful judgment. It also brings forth something called the Bolam test. The Bolam test is twofold. It comes back from a 1957 English judgment. It says that one is a doctor who has acted in accordance with practice accepted at a time as proper by responsible body of medical opinion, and whether the patient claimant was warned of the medical risks associated. There is another landmark judgment for you. This is of the Honorable High Court. This is Arpana Dutt versus Apollo Hospital, which is 2002 judgment of Madras High Court. It said that the patient only requires diligent and proper care if any of the staff of the hospital is negligent in performance of their prescribed work. The hospital will be held liable on the negligent conduct of even, now importantly, borrowed doctors for specific performance of certain operations. Now, we will quickly deal with the process of the guidelines, what the guidelines say, and then come back to IT Act and then conclude it for all of you. The processes are put in point-wise by me because the guidelines otherwise are quite convoluted and repetitive. One, importantly, only medical practitioners registered under the IMC Act of 1956 are entitled to provide telemedicine consultation. Two, RMP or the doctor can decide to use text, audio, video, audio-enabled solutions, or any other mode of teleconsultation, including fax, emails, as he thinks is necessary. It is his sole discretion. If he is using proprietary software, a question will come as to whether the information which is confidential between the doctor and patient can in fact be stored in a server with a third party, and if so, what will be the liability. Another question that has been extensively asked is whether any software, IoT information, whether proprietary softwares, artificial intelligence, Internet of Things, algorithms can be used to diagnose and prescribe medication, because there are a lot of softwares and apps like that. The law is very clear, they cannot be. It can only be done by a doctor. These apps, etc., can be used as an aid by the doctors. It cannot be used to prescribe or diagnose at all. Now, the other protocol is that the telemedicine consultation cannot be anonymous. The patient and the doctor both need to know each other. We need to know who they are dealing with. So at the first is self-identification by the doctor. The doctor has to give his registration number, his name, other details, etc. Before the start of the consultation. Likewise, he has to ask the complete information from the patient. This is very important because there could be chances of giving wrong medication or giving prescription to the wrong person, the prescription being misused, or even in cases where a minor may contact the doctor. In case a minor is contacted, the doctor has to have the consent of a major, somebody who is present there during teleconsultation. Now, the Honorable Supreme Court, another landmark judgment that you might want to note down, has stated on consent. This is Samira Kohli versus Dr. Prabha Manchanda. This is a 2008 judgment, volume 2, SCC 1, which held that the consent of doctor, that the contention of the doctor that consent given to appellant's mother for performing a surgery should be considered as valid consent for performing other surgery. The appellant, the Honorable Supreme Court said, the appellant was neither a minor nor mentally challenged nor incapacitated. When a patient is competent adult, there is no question of someone else giving consent on their behalf. And this brings us back to the issue of consent. You see, if a patient initiates the telemedicine consultation, then consent is implied. In all other cases, you have to take consent. Without consent, there is no relationship between patient and doctor, and that teleconsultation is bad in law. There have been criminal cases that have been filed recently where doctors were asking for consultation fees. Now, the guidelines clarify that the doctor can ask for consultation fee even if the diagnosis prescription is being given by WhatsApp or any of these means. Patient evaluation is the next thing that is done. That it is the doctor's exclusive right to evaluate the patient, to ask him necessary questions, and if he is not satisfied, ask the patient to go for further tests, etc. He can also ask about previous prescriptions, previous medications, and if he thinks that the patient is lying or not giving the complete truth, he can stop the consultation then and there. There would be no legal liability. The guidelines completely protect the patient, the doctor to that effect. The type of consultation can also be is the exclusive domain of the doctor. The patient cannot insist that he wants to have a video chat if the doctor says there is no requirement of a video chat. The type of consultation by law is in three parts. It is called first consult, follow-up consult, and emergency consult. First consult, of course, if the patient is called for the first time, or if he is called after 6 months from the first consultation, or where there is a case where the doctor does not remember what the previous communication was. The follow-up consult is, of course, what the first consult is not. An emergency consult is if there's an emergency and the doctor is contacted, the doctor will limit his advice only to life-saving measures and ask the patient to go for an in-person consult. The medication that can be prescribed is again the sole discretion of the doctor. There are 3 lists that have been given. I will just ask you to read that later because these lists would keep on changing. One is list O, which is over-the-counter list. List A, which is medication that can be prescribed in the first consult when there is a video conference going on, and which is prescribed for refill. List B is prescribed for the same medical condition when there is some add-on medication to be given, and prohibited list medicines that cannot be given. These lists keep on changing, and therefore there is no use getting on them. This is the doctor's prerogative. Now, to know that the doctor can refuse to give advice, the doctor may ask for further tests or refer, the doctor may refuse to take the call, the doctor may discontinue the telemedicine consultation, and can choose the mode of telemedicine, teleconsultation, and also discontinue the teleconsultation if he does not feel there is something right. However, when a patient insists on an in-person consultation, a doctor cannot insist on an non-in-person or a teleconsultation. The prescription laws have completely now changed and now is the domain of the IT Act. Section 4 and 5 of the IT Act give legal recognition to electronic records and digital signatures. We are talking about e-prescription, which will now be the name of the game. The IT Act also has amended the Indian Evidence Act, thereby making electronic record admissible in evidence. Section 2(1) subsection T of the IT Act defines electronic record as data record or data generated, image or sound stored, received or sent in an electronic form of microfilm or computer generated microfilm. So what it means for you is an e-prescription is now a legal document. It can be used. There is no need to print it. It can be used in evidence. and in court of law, and there's also an obligation to store it. The IT Act, of course, when we talk about a third-party software or a third-party platform, which have now cropped up, mushroomed up, so many of them, so the IT Act has taken that into consideration, says there are three parts of any communication: the originator, the addressee, and the intermediary. The originator has been defined under Section 2, subsection 1, subsection ZA as the sender, the generator of any electronic message, in this case the doctor, for example, giving the prescription. The addressee, Section 2L, subsection W, the intermediary is a facilitator to receive, store, or transmit or provide any service, WhatsApp system, proprietary softwares, etc. And an addressee is the recipient of the message under Section 2, subsection L, subsection B. And therefore retention of electronic records, etc. has been dealt. It would be the responsibility of the doctor, and because the confidentiality is between the doctor and the patient, to inform the patient of any breach of privacy laws and take his consent to that effect. Now on technology and privacy, very, very shortly. All relevant provisions of the IT Act pertaining to data protection and privacy laws will be applicable. The doctor is required to take reasonable degree of care to maintain records, and the principle of medical ethics are the governing principles in all these cases. Recently in 2020, the Honorable NCDRC, I don't have the citation right now, I will upload the citation in a while, reiterated the law regarding ownership of medical records. It held that medical record keeping has been addressed in the Medical Council of India Regulation 2002, which are 1. Maintain record performer for 3 years, which is in section 1.3.1. Request for medical record by patients or authorized representatives should be acknowledged and provided within 72 hours, which is in section 1.3.2. And there should be an endeavor to digitize the records, which is in section 1.3.4, where the IT Act and Data Act comes into play. In 2016, the Honorable NCDRC, in another landmark judgment called Loknayak versus KM Santosh judgment, gave a compensation where medical record was not filed by the hospital, and held that it was the primary responsibility of the hospital to maintain the records. The Honorable NCDRC said that it is the primary responsibility of the hospital to maintain and produce patient records on demand by the patient or appropriate judicial bodies. However, it is the primary duty of the treating doctor to see that all the documents with regard to management are written properly and signed. An unsigned medical record has no legal validity. The patient or their legal heirs can ask for copies of the treatment, and which have to be provided within 72 hours. The hospital can charge a reasonable amount for the administrative purposes, including photocopying of the documents, and failure to provide medical record to patients on proper demand will amount to deficiency of service and negligence. It further said that it is the duty of the doctor or hospital to preserve, maintain, and maintain the medical record for certain specified period under different laws like Limitation Act, Consumer Protection Act, Directorate General of Health Services, Prenatal Diagnostic Test Act 1994, Clinical Establishment Registration and Regulation Act 2010. These records are required in medical negligence, accident, insurance claims, etc., etc. Similarly, another judgment, which is Dr. Indu Sharma versus Apollo Hospital, again a landmark judgment, very, very important, something that you should note down. 2015 SCC Online NCDRC 11. It held that person may lie but documents will speak the truth. NCDRC, while holding the hospital and doctors responsible for medical negligence, awarded a compensation of 1 crore. Further, 10 lakh was imposed as punitive cost. On privacy laws, we are aware that this is privileged communication between the doctor and the hospital, and no doctor can be asked to disclose the private confidential information between patient and doctor except under a judicial order. However, there is an exception to that. This is again a landmark judgment of 1998, and it's a very interesting judgment because the name of the parties has been hidden. This judgment is called Mr. X versus Hospital Z, and this is an important judgment because the hospital disclosed the HIV positive test result of its patient to the fiance of the appellant or the patient. When the patient sued the hospital, the court held that it was important for the respondent, that is the hospital, to disclose information for the benefit of the society. So this is an exception to the rule, a very, very important judgment. Internationally, there are various laws pertaining to, various cases pertaining to privacy breach, which have been dealt with over the years, which is something that we can deal with later. Now, very quickly, to end, we will just discuss the jurisdiction in cases of dispute. The telemedicine guidelines have been published in form of an amendment to the Code of Conduct. Therefore, any violation of telemedicine guidelines will be looked as misconduct at the hands of the concerned doctor under the Code of Conduct. A patient who suffers due to this misconduct has a right to complain to respective state medical council to whom the doctor is registered. In CPC, we are aware that it is based on the territorial jurisdiction of the court on two principles: the place of residence of the defendant or where he carries on business or personally works for gain, and where the cause of action has arisen. But these are very, very vague, and there are a number of issues pertaining to that. The Indian courts have taken a holistic view of internet cases and usually place the contractual analysis within the question where the cause of action arose under Section 20 of CPC. A landmark judgment, if you like, to this is the World Wrestling Entertainment versus Reshma Collection. It's a wonderful judgment, something that you should read. It is on similar lines to US constitutional judgments pertaining to the same. Now, to end, Section 11 of the Consumer Protection Act pertains to jurisdiction of the district forum, and as far as territorial jurisdiction, it says a complaint shall be instituted in a district forum within local limits of whose jurisdiction the opposite party or each of the opposite parties, where there are more than one, at the time of institution of complaint actually and voluntarily reside or carries on business or has branch office, etc., or personally work for gain. And B, any of the opposite parties. Now, you'll have to work for gain or reside, and you'll have to take the permission of the forum for that. And third, where the cause of action wholly or in part arises. Now, this is what is important, is because this is where the catch was. The cause of action wholly or in part arises. This increases the domain when it comes to internet contracts, etc. The 2019, as I said, the act which is now to come in force, also adds another, where the complainant resides or personally works for gain. Simply speaking, under the old scheme, which is active today, if a complaint concerns medical negligence, it has to be seen that it can be filed only at a place where the cause of action arose, including the others, as I've said. And now, as far as cause of action is concerned, the provisions of Information Technology Act affect the determination of place of jurisdiction in disputes arising out of or in connection with the internet. The important section in this, it would be section 30, subsection 3, 4, and 5, which we will not read, but it pertains to this. The law clarifies that where the originator or addressee has more than one place of business, the principal place of business shall be considered as the place of business. Where either or both of them do not have a place of business, the usual place of residence shall be the place where the company or that person or that business is registered. Since the cause of action in internet transaction depends on communication, interaction and transaction between netizens, which is mainly through dispatch and receipt of electronic records, the aforesaid provisions of the IT Act will dictate in many of these cases and determine the place or places having jurisdiction in dispute. A very important judgment. Now, this is by a state commission, but again, a very good read for all of you is Spicejet versus Sonia Agarwal. The citation would be, this is for you. This is of the State Commission of Punjab and Punjab, Chandigarh. First appeal number 515 of 2016. State Consumer Dispute Redressal Commission, Punjab, Chandigarh, on 14th March 2017. Here, this is a flight cancellation case where the State Consumer Redressal Commission considered a number of factors under the question where the cause of action had arisen. It found that the contract had been concluded at the claimant's place of residence because this is where the email containing the airline ticket had been received and where the emails rescheduling, cancelling flights had been sent. Further payment for the flights had also been effected at the claimant's residence, so that it could be said that at least part of the cause of action arose there. As I've already mentioned, World Wrestling Entertainment judgment, where it said that online communications are instantaneous communication and therefore the contract would be concluded at the place where acceptance is communicated. Uh, there is one more judgment in Medanta, the Medicity versus VS Tyagi. This is a 2017 judgment. 2017 SCC Online NCDRC 478. The Honorable NCDRC answered a question relating to territorial jurisdiction of services availed at branch of Vedanta. It observed inter alia that part treatment was provided to the deceased at Delhi and therefore cannot be stated to be an incorrect place to litigate. Part of the cause of action therefore arose in Delhi also. To quickly now conclude, there is a huge opportunity which has opened to councils now to guide hospitals and doctors as to the ramifications of neglecting the guidelines and medical negligence laws. It was all right for small-time doctors and hospitals and nursing homes to cater to a very limited audience, patients around them. The reach having increased to pan-India, the presence having come to pan-India, it is imperative for doctors and hospitals to understand medical negligence laws and also to understand what are the ramifications if those guidelines are not followed and if those duties are breached. I hope that this webinar has been of help to all of you, and I hope that you have noted down these judgments and these citations, which have been our research over the years, having handled so many of these medical negligence matters. So this is basically from my private diary, and I hope that it helps a lot of the members, younger members at the bar, to increase their reach and to grow their practice. Thank you, all of you. It's been an absolute pleasure. Thank you, Lawyers Wit. Thank you, Mr. Nanda. Thank you, Kavaljit, for having me here. And thank you, all you listeners. And I hope to see you all again. Thank you.